Welcome, everybody. I know some of you are still rolling in. Tonight, we will be talking about protecting your property for the future. I am Carla Bruni with the Chicago Bungalow Association. I'm the Preservation and Resiliency Specialist. Michael Stone is joining us this evening, and I will introduce him after I get through some of the nuts and bolts of how we're going to run things tonight. We are recording this, so just be aware of that. Also, everybody who signed up this evening is going to get an email within the next couple of days. It'll have a link to the presentation. We're also going to have Michael's presentation included with that. That's Mr. Nancy, my cat, who's been with us on every webinar so far. Sorry. Sorry, not sorry. He's the best. Tonight, though, we're going to be, Michael will be talking for about 50 minutes, and then we're going to do Q&A for the remainder of the time. We're going to aim for general questions this evening. You can't really get into too many specifics, so we'll be sure and tackle as much as we can at the end of the presentation. We'll be stopping at about 7 o'clock tonight. And again, we'll be sending out an email after this with a link to the presentation and also to the recording. We have a few more webinars coming up soon. We'll be posting those sometime probably within the next week or so on the website, so be sure to check that out as well. I think that's it for the main business, but yeah, tonight we will be covering the webinars about, do you know what will happen to your home after you're gone? Have you made plans? Michael's going to discuss estate planning and different ways to transfer properties after you pass away and what you need to know about property fraud and more. Michael Stone is the legal director for the Center for Disability and Elder Law, CDEL for short. As legal director, Michael ensures the high quality of CDEL's legal services, supervises the work of staff attorneys, interns, and volunteer attorneys. He partners with the executive director on the development of legal strategies for CDEL as well. Michael also represents clients in certain matters. He began his legal career in the law firm of Kirkland & Ellis as an associate attorney in the firm's corporate department. He later served as a general counsel for the Cook County Assessor's Office, who's often on here as well, and chief deputy assessor of the Cook County Assessor. He has also served as the chief of staff to the Illinois State Toll Highway Authority. And prior to joining CDEL, Michael was an attorney in private practice. He served as a keystone leader for the John D. and Catherine T. MacArthur Foundation's Preservation Compact, a MacArthur Foundation and Urban Land Institute-led task force on preserving affordable housing. He was also a member of Mayor Richard M. Daley's task force on property tax reform. Michael attended Harvard University as an undergraduate and earned a degree as a double major in government and economics with cum laude distinction. He earned his Juris Doctorate from the University of Chicago Law School. Thanks, Michael. Welcome back. CDEL's done a lot of wonderful talks for us over the years, thanks to Michael. And so it's good to have you actually back on the forefront here. And whenever you're ready, feel free to go ahead and put your presentation up.
Thank you, Carla. Thank you for the introduction, and I am happy to be back. I truly am. So I put something in the chat just a moment ago. We're going to talk about that in a second, but just you can look at the chat if you got it. So I'm an attorney with the.
Sorry, Michael, really quick. I should have mentioned this. We're going to do Q&A at the end, everybody. So please put your questions in the Q&A box down below, not in the chat, but in the Q&A. And we'll get to that all at the end. So just hang tight. Sorry about that, Mike. Thank you.
And with respect to that Q&A, I am happy to answer your questions. Just know that in this sort of forum, we cannot provide legal advice. So we can answer general questions, but we cannot answer your specific questions. So if you start answering asking a question that requires legal advice, I'm going to say I can't answer that question. It's not me avoiding the question. It's just that we cannot provide legal advice in this sort of forum. So in that chat, I put a link to register your attendance. We always like to see who attends our presentation. So if you would be so kind, follow that link and register your attendance. There will also be another link and QR code at the end of the event, which is a survey really about if you want to have the Center for Disability and Elder Law work on your documents, and that begins a conversation about how we can make that happen. So a word about us and what we do. We are a 501c nonprofit, 501c3 nonprofit with a dual mission. We're here to provide quality, free legal services to low-income persons, low-income older adults and persons with disabilities. And we're also here to foster the spirit of pro bono service in the legal community. We're a relatively small staff, 20, and yet we are able to close over 3,000 files in 2023. And that's because we work with most law firms in the city to accomplish the legal work that we do. So we do so through a bunch of different programs that we have. One is focused on community clinics. Community clinics are specific locations that we're at least once a month throughout Cook County. We have 10 locations that are geographically spread throughout Cook County so that one is probably close to where you live. We also have a special clinic that is geared towards the LGBT plus community called Pride to Thrive, that is part of Center on Addison. We do various workshops throughout the county and throughout the year where we may go in and talk about a specific legal issue and then work with the community members to get those that legal issue resolved. For example, we have one on powers of attorney where we come to the community, we talk about the importance of powers of attorney, and then we come back later and we actually work with all the members to draft and execute those documents. We have specific programs focused on adult guardianship, some of which we go into schools and we operate a help desk at the school. We also operate a help desk at the Digley Center downtown, and we provide direct representation for adult guardianship. And then we also have a program that's focused on housing preservation, and that's what we're talking about today. This program is about preserving home ownership for primarily older adults and persons with disabilities, to identify and resolve issues such as title issues, but also plan for succession of the home so that generational wealth is passed to the next generation. So CEDO has some specific practice areas that we deal with. One is estate and end-of-life planning. That's part of what we're talking about here, that specifically the transfer on death instrument, which we'll get into a lot more later. But we work on other estate planning and end-of-life planning documents. We mentioned housing, we mentioned adult guardianship, but we also do some simple divorces and collection and consumer debt matters. In order to be qualified for our services, you must meet these 4 criteria. First, you must be a resident of Cook County, or your legal issue must be in Cook County. You must be over the age of 60 or an adult living with a disability. We prioritize low and moderate income. For us, that means in general that someone is at or below 200% of the federal poverty level. The federal poverty level varies by year and by household size. So it can vary for the individual analysis. But it is something that you can Google and find out what the federal poverty level is and what 200% of the federal poverty level is. We do have certain grants that support our work, and some of those grants vary as to qualifications, particularly on the what's considered low or moderate income. So it's possible that you might be on the cusp of one program, but qualified for another. So in general, we usually encourage people to go ahead and reach out to us if they're not sure whether or not they qualify. And then finally, the criteria is that it must be one of those legal issue practice areas that I mentioned on the slide before. So why is planning for your home important? So there are lots of client stories we can share in this area. But one in particular that comes to mind that is recent was a potential client who called us up and couldn't understand why her taxes, her property taxes, were so high. Upon further research, we found out that her house was not in her name, that she had actually inherited the house 20 years ago, and since then hadn't been taking such property tax exemptions as the homeowner's exemption, and in her case, the senior exemption and the senior freeze exemption. So if her prior generation, her mother, had planned for the home, made sure that title was transferred upon her death, she would have received this benefit of the property tax exemption for all those years. So planning for your home can be important as such thing as making sure your heirs, the people that you want to inherit your home, are on title to the property as soon as possible in the least affordable or the least expensive way possible. It can allow them to take actions immediately on the property, such as making needed repairs or paying taxes or paying back taxes or taking those exemptions. It also allows them to quickly and affordably sell the home if that is the choice, the route of choice. So planning for your home is in part important because you want to make sure your next heir, your heirs are on title to the property. But there's also other considerations, and that's you don't want your heirs to have to go to probate if they can avoid it. So what is probate? I think most people have heard of probate, but if they've heard of it, they've probably heard of two things: that it's expensive and it takes a long time. So probate is the process through which the court goes through to supervise the distribution of your assets after you've passed away. So that means everything from your home to your furniture to your bank accounts to your cash, anything that's part of the probate estate, the court is responsible for supervising the distribution of those assets to your heirs. When you're in probate court, the court will choose someone to oversee that responsibility, the responsibility of not only distributing the assets, but paying the debts of the decedent, and determining what is to be distributed according to whether or not the person had a will, if a will existed, or according to law, the law of intestate, if the person did not have a will. So why is probate so expensive and time consuming? Well, one of the reasons it can be expensive is that the court will often require the person who is responsible for that distribution and paying of debts, either referred to as an administrator or an executor. That person often must post a bond, and the bond tends to be 1.5 to 2 times the amount of the value of the estate. Bond is like an insurance policy, ensures that that administrator or executor does what they should do and pays those debts properly and distributes the assets and doesn't take off with all the money. And as a result, that insurance policy ensures to the court that that person acts responsibly. In Cook County, at least, bond companies generally will not issue a bond without an attorney. So that adds 2 levels of expense. So you have the expense of actually paying for the bond, but you also likely will have to hire an attorney to supervise the process. So with all that in mind, when is probate necessary? Probate is necessary if the decedent, the person who died, had assets worth of more than $100,000, or the decedent owned real property that needs a transfer of title. There are other reasons that probate may be necessary if there's a dispute among family members or the potential heirs, whether or not who gets what, that might require probate. If there are certain types of unknown or unpaid debts, there might be it might require probate. And if there are allegations that someone had undue influence, for example, had undue influence in the drafting of a will, probate might be necessary in those cases. There are ways to avoid probate, and what we're here to talk about is a way to avoid probate, if possible. If when a probate is is not necessary. Something called a small estate affidavit can be filed. A small estate affidavit is a relatively short form that a person can file without an attorney, although a lot of times attorneys are consulted. But it is a document that is designed so that it can be filed without an attorney, so you don't have to hire the expense of hiring an attorney. It is requires that no real estate be transferred through the small estate affidavit. We're going to talk about a way of, even if you own a home, that it cannot be transferred through the probate or small estate affidavit. The assets must be less than $100,000, and there can be no disputes. So a small estate affidavit is one way that probate can be avoided. So looking at that $100,000 limit, what's included in that $100,000 limit? It's anything without a beneficiary. So if you have a checking and savings account and it's a normal standard checking and savings account that's in the person who died in their name only, then that's counted towards that $100,000 limit. So if you're fortunate enough to have $100,000 in a banking account, you're not going to be able to use a small estate affidavit. Other things that are personal property that's included in that $100,000 limit, a vehicle, if it's not a pay on death title, that is something else that can be done. Personal items like furniture, clothing, all that gets lumped in there as a transfer without a beneficiary. Items that are excluded from that $100,000 limit are anything with a beneficiary. If a home is transferred to a transfer on death instrument, we're going to talk about that. It's also called a TODI. That's not included in that $100,000 limit. And it also excludes that transfer of real estate through the small affidavit. Bank accounts that are pay on death accounts. That is a special type of an account. You can go to your local bank, whether it's Chase, you ask them to make it a payment on death account that only goes into effect after you die. So that person that you would name would not have access to your checking or savings account until after you die. So it's protected while you're still alive. But if it does get transferred automatically on it by a payment on death account, it doesn't get counted against that $100,000 limit. If you've made your car a payment on death vehicle or your title to be pay on death, that similarly won't get counted against that $100,000. And it has the benefit of happening automatically, so your heirs will not have, your beneficiaries will not have to go through any sort of process. It just happens automatically. If you have life insurance and you've kept your beneficiaries up to date, that's not going to be counted against your $100,000 limit. Same thing with our IRA. If you've put a beneficiary there, your 401k, you've put an up-to-date beneficiary there, it's not going to get counted against the $100,000 limit. Other things that can be excluded from the $100,000 limit, if you own property jointly. So if both of your names, if you have both spouses on the name to your car, that's owned jointly. And when one passes away, the other will inherit it. Same thing with your own. Although with your home, you have to be specific about it being owned jointly. And it needs to have the language of joint tenancy or joint tenancy with rights of survivorship, or to be owned by tenancy by the entirety. That's a special sort of way of owning your home between spouses. But if it's owned in that way, the surviving spouse automatically inherits the home, and it doesn't have to go through the probate process and won't be included against that $100,000 limit. So I mentioned the transfer on death instrument, or the Illinois transfer on death instrument, also called a TODI. That is one way to transfer your house outside of the probate process automatically upon a person's death, and excludes the house from the probate process, it allows someone to file that small estate affidavit when the person passes away. So this is an example of what one looks like. It is a simple 1 or 2 page form. If you've ever seen your deed, it looks very much like your deed. And that's intentional. The law requires it to look a lot or have the qualities of an inter vivos deed, which just means a deed for your property. So that's an example of what one looks like. So what is a toady? It is a short form recorded with the Cook County Clerk's Office or any county clerk's office or recording division. In Cook County, the fee to record one is $59. It's very cheap. It used to be twice that amount. We actually argued with the clerk's office and the county to reduce that amount to make it a much more affordable and useful tool, which they've agreed, and they've been able to keep that amount really low. So it's to make it effective, it's only a one-time fee to record it, $59. It, however, must be recorded before the homeowner passes away to be effective. So you want to make sure not only do you complete it, finalize it, execute it, have it witnessed, have it notarized, but it also must be recorded with the county clerk before it's effective, before the person dies. If someone tried to record it after a person dies, it wouldn't be effective. But that document names the beneficiary or beneficiaries who will receive the home after a person passes away. It avoids probate. And the beauty of it is, while a person is alive, it has no effect. So if a person changes their mind about who they want to inherit their home, all they have to do is record a new document that lists the new beneficiaries. Or if they decide that they want to use a different tool for estate planning, they can record a document that says that this transfer on death instrument is not effective. It is not something that you have to notify your mortgage company that you've recorded it. It literally has no impact on the property until after a person passes away. So who can do it, Toby? The homeowner, and only the homeowner. So we sometimes have well-meaning children who want to do things for their parents. And they want to make sure that their parents have a complete plan, even if it's not for themselves, that their parents have a complete plan for their home. Well, well-meaning children cannot do this for their parents. Only the parents, because they're the homeowners, and they have to have what's called the mental capacity to do the toady. That means that they understand that they what they own. They understand the effects of the documents. They understand the effects if they don't execute the documents. They understand that they have a choice. But if they understand, they make these requirements of mental capacity, then they are able to do a toady if they want to do a toady. So what happens after a person passes away if they put one of these toadies in place? Well, the beneficiaries would record what's called a notice of death and acceptance of the toady and attach your death certificate to that document. It costs them $107 to record it. They are, by filing the document, they are assuming that they are notifying to the world that they want to inherit that home. They do have their choice. They don't have to inherit the home, so they could decide not to inherit. They do so by disclaiming the interest in the home. But if they've decided that they want to own the home, it's as simple as $107 to record it, and they're avoiding the expenses that I said earlier of the attorney and the bond and any miscellaneous court fees that might go along with trying to go through the probate process. So some common questions that we happen across. First is, I have a will. Doesn't that help avoid probate? Answer to that question is no. Having a will on its own is not enough to avoid probate. So probate, again, is that process where the court appoints someone either as an administrator or an executor who is responsible for seeing the process carried out. The court then will, it may decide whether a valid will is in place. A will itself will be an indication to the court of what the person who passed away, what their wishes were. And it's going to make that probate process easier, certainly, and certainly a valid will is going to keep with the wishes of the person who died as to who gets what. But that in and of itself, a valid last will and testament does not avoid probate. So a question we often get is, I do not have a will, so the state of Illinois gets my property, right? Answer to that question is no. If you pass away without a will, Illinois decides who gets what. In fact, the state is going to try really hard to make sure that someone inherits your property, because in general, they do not want your property. So the law of intestate decides what order of who gets what. And it essentially creates a hierarchy of individuals, beneficiaries, who would inherit a person's stuff after they pass away. That hierarchy in general follows closest blood relative, beginning with the spouse and children, and then gets farther and farther away. And only if no kin can be found would potentially your home go to the county, and everything else would go to the state of Illinois. But believe me, the state and county tried really hard to find a person who would inherit your home. So we talked about the Illinois Transfer on Death Instrument, the TODI, as one way to remove your home from the probate process. But there are other ways. One common way is individuals who try to quit claim their property to another person. Very common for someone to say they're going to quit claim their deed to themselves and their child, to make themselves joint tenants on the property, so that an individual, when mom passes away, the daughter automatically inherits the home because they own the home as joint tenants with rights of survivorship. So that's one way, doing a quitclaim deed. Another common way is a trust. A trust is a legal entity by which you transfer items, ownership of items to the trust. So you are no longer the owner of an item or an asset, the trust is. So for example, you might transfer your home to a trust. Trusts, actually I'm going to talk about on the next page about the advantages and disadvantages of these different strategies. Know that trust, first of all, that's something that Center for Disability and Elder Law cannot help you with. We do not work on or create trusts. And I think you'll find that very few legal aid agencies do. But you should know that in general, to create a trust, you're going to need an attorney. To do so, I would strongly not recommend an individual try to create a trust on their own without legal representation, which means that you are going to encounter time and costs of creating a trust. So this chart is a simple comparison of the quitclaim deed strategy versus the transfer on death instrument strategy. Two different strategies of passing your home to the next generation. So that first one is an indication of who actually owns the home under each one of these strategies. So under the strategy of using a quitclaim deed, where a person would where a person, where you and, for example, your child would own the ownership of the property together. Well, it is exactly that. So you and someone else own the home together when you do a quitclaim deed to establish joint ownership. As opposed to a transfer on death instrument, you own it while you're still alive. As I said, transfer on death instrument has no impact while you're still alive. So a big disadvantage of owning something jointly is that you own something jointly with the other person, which means they have the right to act as owner. So that might mean that they have access to the property, or it may mean that they can encumber the property with debt. It also can mean that if a creditor comes after someone that you jointly own the property, they might actually come after the home. So the scenario is that daughter gets into a car wreck and gets sued, and even though a daughter may not want someone who's suing her to come after your home might be the subject of daughter's debts. So it's always something to consider carefully when you are adding ownership of your home to someone else, even a closely trusted relative. Fees. So do a quitclaim deed, you're going to have to pay the full $107, and I think it's actually more than that now. I think it's gone up to $117 or $16 for a recording fee. You also may encounter municipal fees, depending on where you live. Your local municipality might have additional fees that it charges, as opposed to a transfer on death instrument, $59 and you're done. When is it transferred? Under the quitclaim deed, it happens immediately. On transfer on death instrument, again, nothing happens while you're alive. So it only happens after you pass away, and you're able to change your mind if you do so before you pass away. What happens if you change your mind? Well, if you have a quitclaim deed, you have to go back to the other owner, even if it's your daughter. Now, even if everyone agreed, you now need to get your joint owner's permission to either take them off the deed or do something else, or even sell the home. Transfer and death instrument, you change your mind, you record a new document. Both avoid probate if, in the case of the quitclaim deed, if you're still joint tenants. Although we do see situations where one person takes steps to end the joint tenancy, and sometimes they run tenants in common. And then you're not avoiding probate. You're actually back in probate world. We already talked about the creditors. You talked a little bit about expense. And then finally, if you do a quitclaim deed, you really should seek your lender's permission before you do so. So those are the comparison. I want to take a little time to talk about other things to consider other than just planning for the home, particularly as individuals grow older. When you other estate planning documents for your health care, you should consider a power of attorney for health care, and a living will declaration, depending on your end of life wishes. Many people assume that closest relatives will be able to make these decisions with respect to healthcare as they grow older, or their spouse will make those decisions. Many considerations to go into that decision on whether or not to do power of attorney for healthcare. But I would, if I was giving another presentation, I think I would convince you of the importance of doing a power of attorney for healthcare, even if you are going to choose a close relative or spouse to be your power of attorney. Similarly, a power of attorney for finances and property. This is about what happens with your assets while you're still alive, creating someone or giving someone the power to deal with your real estate, with your finances. It's called, in Illinois, it's called the power of attorney for property, but it covers much more than just real estate. It's about finances, bank accounts, the ability to pay bills, ability to incur debt. So again, if I was giving another presentation, I would give you all kinds of reasons as to why the power of attorney for property is important, and why you should have one. And finally, having a last will and testament, that is for an individual after they pass away, about who should inherit your assets upon your death and what to do. So a few other things to keep in mind. Protecting your home against fraud. We've seen an uptick in fraud with respect to homes. In particular, fraudulent people filing phony quitclaim deeds against homes, other documents filed against homes. One protection against that is to put your home on a property alert. The Cook County Clerk's Office, I'm not sure about other counties in Illinois, but the Cook County Clerk's Office has a property fraud unit. If you follow that link there, you can sign up to be alerted when an item is filed or recorded against your home, so that you are notified quickly once something has been filed. Oftentimes in these cases, the quicker you know about something, the better off you're going to be. I think the county also allows that filing to be done by phone or email, but you begin with that link there for signing up. If you are the subject of some fraud, the Cook County Clerk's Office also has a fraud unit, and can begin that process of either investigating, or in some cases, they will go to an administrative judge to take steps with respect to that fraud. They don't do so in all cases. They do have some criteria, but it is at least being notified that something fraudulent has been filed against your property. I mentioned in that first story about the client who inherited her home 20 years ago and had failed to take all these exemptions and was confused at why her property taxes were so high. There's lots of exemptions out there, particularly dependent upon your individual situation. So you want to make sure you're taking your homeowner's exemption. You want to make sure you're taking your senior exemption if you're 65 or older. If you're 65 or older and make less than $65,000 a year, you want to make sure you're taking your senior freeze exemption. There's a persons with disabilities exemption. There's a returning veterans and veterans with disabilities exemption. Depending on your situation, you want to make sure that you are taking the proper exemptions. And then what happens if you are the person who hasn't been taking those exemptions for a really long time? Well, the Cook County Assessor's Office has a process called certificates of error for claiming prior missed exemptions. Right now, you can claim those exemptions up back to tax year 2018. I got to tell you that that's been unusual. I think it's been a product of the pandemic. Usually the assessor only lets you go back for 3 years. So if you're in that situation, you want to make sure you do that soon, because I don't know how long the assessor is going to continue to allow exemptions to go back to 2018. Other opportunities for savings, there's a senior citizen sewer exemption, there's the garbage fee discount. If you're having issues with utilities, gas, electric, there's the low-income home energy assistance program, or LIHEAP, out there. Then finally, I want to end, or near the final, I want to end this conversation on the fact that no one size fits all. Particularly as people have more income, more value, or their situation becomes more complex, it does become necessary to consult an attorney and making sure that your unique situations are met. Transfer on death instrument is a really good, simple, low cost, easy to do solution, but it's not a solution for everyone. we want to make sure that you understand that, particularly, as I said again, as someone has an estate or a home or situation that becomes more and more value. There might be other tiny considerations to make. So I gave you a link at the beginning of the presentation. This is a link and a QR code. They do the same thing. If you follow this link, this is for people who are actually looking to work with the Center for Disability and Elder Law on these documents. Last time we gave this program, we had a lot of you who were very interested in working with our offices on this document. Keep in mind those eligibility requirements that I listed early on. You must meet those 4 requirements, including that you must be in Cook County, you must be 60 years of age or older, or an adult with a disability. You must be low or moderate income, keeping in mind that 200% federal poverty level. And for these purposes, we're only talking about working on that transfer and death instrument. So if you meet those criteria, follow that link or take that QR code and reach out to us. If you're here just to listen for someone else, thank you. Thank you for listening and passing on this information to that friend or family member. If you think that they want our services or should seek our services, you can have them call that pre-screen line number, which is 312-376-1880. That is staffed Monday through Friday, 9 a.m. until noon on business days. So that's Monday through Friday, 9 a.m. until noon. But if they reach out to that pre-screen line, they will begin with a 5 to 10 minute conversation, which collects some basic information from them and indicates, begins the process of whether or not they will qualify for our services, and which will lead to, if they do qualify for our services, which will lead to longer conversations and a process to draft their documents. And so with that, thank you so much for this opportunity. I'm actually going to leave the link and QR code up just in case someone still would like to see it. But otherwise, I am open, Carla, for Q&A.
Great, thank you so much, Michael. So much good information in there, and some good questions in here as well. So I guess I'll just launch in. And everybody, we're going to stop right around 7 p.m. tonight. But again, if there are more general questions we don't have a chance to get to, we'll be able to get those out to, we'll be able to capture those and then respond later. We're going to send another follow-up email out after this again with a link to tonight's recording and also to Michael's presentation. So, all right. So question 1, will the Cook County Clerk staff review a TOTY for accuracy prior to filing? Can errors when completing the form cancel the TOTY in the event of a death?
So the Cook County Clerk's Office will not provide legal services. So they will not give you a legal opinion as to whether something qualifies or really kind of interpret the validity of a document other than on its face. So they're going to look for things like, is it signed? But they're not going to tell you whether it's a valid signature or whether the person who signed it did so with authority. However, we actually operate a help desk that operates out of the Cook County Clerk's Office. We're there right now once a month. And a lot of times, if you have a legal question, if you visit the clerk's office and you have questions, we might be able to assist you with your legal questions as part of that help desk process. So short answer, Cook County Clerk's not going to tell you, give you any legal advice, but you might be able to get some answers through our help desk.
Great. A couple people asked about where to get a TODI notarized because it looks like, for at least for one person, they specified their bank and the notary at the currency exchange said they couldn't notarize documents pertaining to real estate.
I've heard that before, that some banks and some currency exchanges will not simply notarize a document. And I don't have a great solutions for you. I know we only notarize documents that we actually work on. Sometimes there are libraries who have done it in the past, but I know that there are currency exchanges that do them, just that some currency exchanges do not.
Interesting.
And in general, banks won't notarize this sort of document.
In general, banks won't, you're saying. Okay.
Yeah.
Interesting. Okay. Idea. Can you use a pay on death designation and TODI for 2 beneficiaries each?
So I'm not sure that I quite understand the question, but under the transfer on death instrument, you can have multiple beneficiaries. When you have multiple beneficiaries, you should be asked if you're working with an attorney or someone who's drafting it, or if you're using the form, there's usually a checkbox about how those multiple beneficiaries will inherit it, either as tenants in common or as joint tenants with rights of survivorship. So joint tenants means that if one passes away, their heirs will inherit their share. Joint tenants means that if one of the beneficiaries passes away, the other beneficiary inherits it, in the same situation where you would have as a spouse. So you can have multiple beneficiaries on the transfer on death instruments. You can make it conditional. If one set of beneficiaries passes away, then the next set of beneficiaries inherit. That can all be part of the TODI itself.
All right. Does the taxable basis on residence and investment property change? Does the taxable basis on residence and investment property change when passed at death through a trust?
I would say that is a question that I cannot answer. I would certainly, and that's going to be very particular to your own situations. So that is something you definitely want to consult your tax advisor about the impact of transferring it.
Okay. Is there a way to avoid having a nursing home or a care facility take away your home if your spouse requires long-term care? And the second part of that is, what if you live in 2 different homes over the course of a year, like a snowbird situation?
So let me start with part 2. You are not, unlike property taxes, for example, in Illinois, you're only allowed to claim a homeowner's exemption on one parcel. So you're required by property taxes in Illinois to designate one property as your primary residence, even if you have 2 residences. So you can't claim property tax exemptions on 2 residences in Illinois. That's not true of TODI. You can do TODIs on as many properties as you own in Illinois. But one thing to keep in mind, you mentioned snowbirds. TODI is a state law. So whatever state your snow property is in, you want to make sure that they have an equivalent transfer on death instrument for that property in that other state. Right now, 35 states have adopted similar laws, but not all states. So you want to check to make sure that property, that this law exists in those other states before you go out and record it, and the exact process in that other state. And then I forgot what the first part of the question was.
Is there a way to avoid having a nursing home or a care facility take away your home if your spouse requires long-term care?
Yeah. So that is a common question for people who are looking to do either Medicare or Medicaid planning, as to are there steps that you can take to avoid Medicare or Medicaid making a claim on, usually after a person dies. I would suggest that you talk with an attorney on that particular step. There are steps that people take, but it is really something that you should talk to an individual. You should seek legal advice on your individual circumstances.
I filed a TODI a few years back and designated both my daughters as beneficiaries, but since then one has died. Do I need to file a new TODI, or can my living daughter just present her sister's death certificate and mine upon my death when filing the notice of death?
And that kind of relates to the answer I gave a little bit earlier, as to you can set up the TODI in different ways. You can set it up so that your persons inherit as tenants in common or as joint tenancy. If they were set up as joint tenancy and one person has passed away, then that survivor is going to inherit. If it was set as joint tenancy, it could be that the person who's passed away, that their heirs will inherit it. It also can be set up so that depending on the language of the TODI that you use, whether or not it considers if a person passes away before you do. So there's a language that you can use that says that if one of these individuals passes before me, then this happens. So it's very possible that that is part of your TODI as well.
Should you expect any problems getting a TODI if you want to terminate a land trust?
So you would not have a TODI at the same time as you have a trust. It's two different strategies. If you are terminating a trust, that would involve transferring ownership back to you as an individual as opposed to the trust. If you take that step, you should be able to do a TODI. But you have to take that first step of transferring ownership back from ownership by the trust to the individual. A lot of times people just let the trust expire by itself, meaning perhaps there was some sort of annual fee or they had to pay annually the trustee. That in itself, if you just fail to pay those fees, that in itself doesn't terminate the trust. That just creates a problem that you'd have to resolve before you'd eventually have to resolve. But that in itself, not paying the fees, doesn't terminate the trust.
Okay. Can you provide examples of good reasons to get a power of attorney for property?
Sure. So a classic example is individual goes into a coma. And while they're in the coma, property taxes have to be paid, or utilities have to be paid. And it needs to be paid from the individual who's in a coma from their bank account. The power of attorney for property allows those sorts of steps to be taken. It can be very important if someone goes in a coma and then, a month or two later, they wake up from that coma. So when they wake up, they want to hopefully find that all those issues that should have been taken care of while they were in a coma have been taken care of, including paying bills and paying taxes or paying mortgages, those sorts of things. The power of attorney for property in Illinois is really broad. So it not only covers that example where someone's in a coma and can pay bills, utility bills, mortgages, property taxes, but it also allows to take steps with respect to all steps with respect to real property. So the person could sell the home if it was in the best interest of the individual, buy property if it was in the best interest of the individual, settle things like IRS debt matters or IRS claims, resolve securities matters, bond matters, insurance matters. It's pretty broad, and someone should always consider how broad it is, and when giving someone that sort of authority, and whether that person is a trustworthy individual or the best person to resolve those issues. But provided that it is a very valuable tool, particularly as someone ages and particularly when someone might be beginning the process of dementia. We see all the time where someone has gone the route of, or might have Alzheimer's disease or related dementia, and they can no longer make decisions on their own. And well-meaning child comes and says, well, dad can no longer handle these affairs, and I need authority to make those decisions and take those actions on behalf of dad. Well, you want to make sure that that power of attorney is in place before it's too late, because if it's too late, the only way, the primary way to resolve that issue is to seek guardianship of dad, which is another court supervised process that can be long and expensive. So powers of attorney is a way to resolve it before you need it, and it's a really cheap way of something problem that might become very expensive down the road.
Okay, great, thank you. Other than a quitclaim deed, how else can you avoid probate?
So there basically in Illinois there are three routes. It's that quitclaim deed. It's the trust. Again, that the trust is going to be a tool created by I highly recommend an attorney, or the transfer and death instrument. So those are the three main ways.
Okay. We have a few people asking where they can get the where they can actually download a TOTI form.
The Cook County Clerk's Office on their website has a number of different forms, including a transfer and death instrument form. So it's a model one. There are slightly different versions of TOTIs out there, but that's a good one.
Okay. Great. And that was the Cook County Assessor website, you said, right?
No, the Cook County Clerk.
Sorry, Cook County Clerk. Okay, Cook County Clerk website. That's why I'm double checking. All right.
Illinois is a little confusing in that we have something called a clerk of the circuit court. That is a different person than the Cook County Clerk. Formerly, it was Karen Yarbrough, who recently passed away, but that is the office that you want to go to.
Okay. Another person asked if it was possible to put the fraud link in the chat. Where would that be found?
Yes, it's in the presentation, and
we'll have that going out as well. Okay.
Yeah.
Just saw that.
Yeah. There it is, if people want to copy it right now.
Cool. Okay. Yeah. So again, everybody will be sending this out in an email, the presentation and the recording. So we'll have all this good stuff as well. Okay. Are the saving exemptions only for seniors 65 and older?
I think you're talking about this screen, which is about the property taxes. The senior exemption and the senior freeze exemption, you have to be 65 years of age or older. Homeowners exemption, as long as you're 18 and own a real property, you can claim that.
Okay. This one was actually a version was emailed to us as well. So, and it might be too specific, I'm not sure, but somebody who's concerned that their children would blow their estate on frivolous trinkets from Amazon and wanted to know, can my adult child executor disperse my trust assets at milestones I set for a 10-year period? Is that a kind of thing you can set up?
So I think what you're trying to do is govern how your assets are spent after you pass away. You can't do that through a last will and testament. You would have to set that up through a trust. So if that is what your goal is, you'd have to certainly look at a trust for how you control your assets even after you pass away.
Okay. Lucy, hi Lucy. Lucy's wondering if it's true that if you have a senior freeze, you should not appeal because it will remove you from the freeze rate. Is that?
So no, I don't think that is accurate or true. So usually when you have a senior freeze, you do want to make sure that the initial rate is as low as possible. So you're looking to appeal the value of your home prior to the exemption. If you're talking about a unusual circumstance where it was frozen at one level and you peeled it and somehow got it below even the freeze level, I'm not sure why that would be why you would consider that to be a disadvantage, but it shouldn't negatively impact your freeze.
Okay, yeah, it seems like if you appeal it, there's concern that it'll knock you out of the game. They'll look at it again and then take it away from you. So, so maybe that's just a myth that's going around right now. Many are out there, Lord knows. So,
that shouldn't happen. And if for some reason you somehow got knocked off your senior freeze, I would reach out to the Cook County Assessor's Office to let them know. It might be an administrative problem, but it shouldn't be a policy that somehow appealing your taxes would take away your freeze exemption.
We are after 7 already. That blew by really quickly, Michael. So we will, again, we're going to go through and we'll copy these questions out. If there are things that are appropriate for CDL to answer, they can't give actual personal legal advice, as Michael said. So things that are too specific, probably we won't be able to, respond with, but the CDL is willing to go through the more general questions, and we can drop those in an email to you guys as well, those responses. Michael, thank you so much again. So valuable, all of the information you have. This is such a common issue we have with a lot of our members, so we really appreciate it. Thanks to everybody for hopping on tonight on an incredibly beautiful evening to sit here with us. And we will see you all soon. Okay. Thank you.
Thanks for having me.
All right. Have a good one, Michael. Take care.